Hi everyone, you are watching Behind the Sidelines, your one-stop shop for understanding the forces at play behind the sports we watch. I'm Pacchia.
And I'm Steve Olenick, and today we have got a phenomenal guest, Marc Edelman, sports law and antitrust expert from Baruch College. Marc, thanks for being here.
My pleasure.
The O'Bannon NCAA ruling, what happened, who won, walk us through it.
Right, big case. Everyone in the media is either coming down on the side that the plaintiffs got a victory in this decision. Other people are saying not so fast. I guess that's the contrarian opinion out there in the media. If you were to assign a score sheet here, you know, who gets the W, who gets the L?
The W goes to the plaintiffs in this case, but not by knockout, by decision.
All right, fair enough. Why is that?
Judge Wilken issued a 99-page opinion in this case. And the thrust of all of these 99 pages, if you boil all of that down into one sentence, is that the NCAA violated Section 1 of the Sherman Act, that they colluded to restrain trade for player salaries, and that these athletes had a right in an education market to compete for compensation between school and each other. That sounds great. That sounds earth-shattering. But here's the catch. At the very end, a permanent injunction was put in place by Judge Wilken. And while one would expect that to create a free market for prospective Division I football and basketball players to compete to sell their services to the schools, instead Judge Wilken said that the schools, without violating the NCAA rule, if they choose, could put aside up to $5,000 per player per year in trust.
And Marc, let me ask you this. How did they come up with this $5,000 number? I just don't think it's gonna like coerce or convince some student athlete that's a big time athlete to stay in school.
It seems like an arbitrary number to me.
It seems very arbitrary at first, but if you get into the opinion, you get into the procedural history, there's a reason for it. Maybe not a good one, but a reason for it. Here's what happened. One of the issues in antitrust law is about providing for the best product for the consumers. So at trial, one of the things the NCAA presented was an expert study in which their expert asked a whole group of consumers whether they would be more or less interested in watching college sports if the athletes got paid.
Now, just to stop you here, this is a study that the NCAA paid for and produced?
That's correct.
Okay.
The NCAA paid for and commissioned the study. And the study had many problems with it. But what the study found, if you accept it as being an accurate and fair study, that a majority of the consumers interviewed said they would be less interested in watching college sports if athletes got paid a sum of money.
Let's do a little antitrust law 101 if we could. We were talking before about the concept of an antitrust exemption. There are certain industries and sectors in the United States that are allowed to opt out of federal antitrust law. Can you walk us through the process of getting such an exemption, and do you see the NCAA moving to get said exemption down the road?
Well, there are two types of exemptions that theoretically could exist. Statutory ones, which mean that they're in statute or code, and you have to go to Congress to get a statutory exemption. And we also have non-statutory exemptions. And non-statutory exemptions to antitrust law mean they're not given to you by Congress, but rather the courts have determined that such exemptions are implicit or needed to be there. One example of a non-statutory exemption is in professional sports. When the players are unionized, most of the agreements that are reached between the teams in the league and a unionized set of players are exempt from antitrust law, not by statute, but because the fact Congress has found that labor law needs to preempt. Now, in the context of the NCAA, if they're looking for an exemption and the players are not unionized, so it would not fall under the non-statutory labor exemption, they would have to go to Congress and convince Congress to pass law to either separately regulate the NCAA or to, for some reason, say that antitrust law is not an appropriate way of regulating them. And that would be good old-fashioned lobbying. The interesting part with respect to this lobbying, however, is the members of Congress are chosen on behalf of their states, and some of the largest college sports programs, the ones that care the most about maintaining the status quo, are public institutions within that state, meaning that they might be in a somewhat better bargaining position when they go to their congressperson than, say, a simple private individual and an entirely private business might be.
So what are the odds that the NCAA goes in front of Congress to ask for an exemption?
I think the odds are extraordinarily high. The NCAA wants to maintain its status quo. Like many cartels out there, the NCAA believes that it does good things, and thus it should not have to comply with the same law that other businesses do. And we've seen this argument for over 100 years. We've seen the big oil companies telling us they're different and they shouldn't have to follow antitrust. We've seen the large train companies saying we are different because we have high fixed costs. We shouldn't have to follow antitrust. The NCAA feels the same way. Now, up until now, they have not gone to Congress to petition because courts have always, through some weird exemption or another or interesting reasoning, have not found the NCAA liable with respect to restraints on their players under antitrust law. But now that this changes, it seems their first line of defense might be to attempt to get this overturned in the Ninth Circuit Court of Appeals. And if they can't get this overturned, their next would be go to Congress and try to get the law changed.
Is that what you think is going to happen next, off the appeal?
I think there will be an appeal for certain in this case. It will be challenging to get this overturned on appeal. I'm not sure exactly what grounds the NCAA is going to rely upon on their challenge, but it's well settled as a matter of antitrust law that you're only supposed to be able to balance anti-competitive effects against pro-competitive benefits in the same market, which means, as the district court properly concluded, things like this is good for education or it creates more opportunity for women's sports are entirely irrelevant to the antitrust analysis. And to that extent, Judge Wilken was entirely correct in ignoring them. In fact, she might have given them some weight and too much weight by acknowledging them at all. So I don't think this will be overturned on appeal, but you never do know. There is case law pushing in both directions.
Right. Mark, last question. NCAA 5 years from now, what does it look like?
Unless the NCAA is able to get an exemption from Congress, I believe the NCAA will look like an administrative body. It will have very little power from the economic point of view. The large power will lie in the individual conferences. The conferences will be passing their own rules on a conference-wide level about how to compensate and not compensate college athletes. Big-time conferences like the SEC that want the best athletes will be moving very much in the direction to a free market for their services.
Wow.
On the other end, conferences like the Ivy League that are able to compete for the best athletes with bona fide education probably won't have to pay at all.
Wow.
And then the Big Ten, let's talk about them, because we have a great prisoner's dilemma here. The Big Ten has always said we're not going to pay our college athletes.
Yeah.
In fact, it was the Big Ten that helped create the NCAA to prevent other conferences from doing so. And the best outcome for any Big Ten school is no one paying their athletes. But the minute that breaks down and the SEC schools start paying their athletes, the Big Ten schools will have a choice. Maintain the status quo, but not get the best players, best TV deals, best revenues, or keep all the revenue and compete in the free market.
Yeah, and it's hard to see everyone marching in unison going forward once you start to see other schools starting to pay their athletes. Mark, this was really fascinating. That's Marc Edelman, professor at Baruch College. If you'd like to see more of the stuff that we're working on, be sure to go check us out on the web. You can see us at www.mimesiswebtv.com. You can also follow us on Twitter, and of course, you can subscribe to us on YouTube. I'm Pacchia. Thanks for watching.